Mr. Kitchens was a participant in Overt Act 75, and in looking at the new indictment, I do see that his name apparently has been inadvertently left off, but that does not in any way mean that the state is now suggesting that he was not a participant in that act. This is a case wherein we have circumstances involving attempts to serve witnesses who frankly break down and cry out of fear that harm will come to them if they are required to come into court and testify. We have evidence that there are members of this organization that are named in this indictment who have in fact conveyed their willingness to whack or to kill a person for the defendant. And given that there has been no substantial change in circumstances, we would ask that the court deny the defendant's motion for bond reconsideration.
Now, when you mean the last statement you made, whack or otherwise, who are you referring to? Are you referring to Mr. Kitchens? You referring to Mr. Williams? Or who are you referring to? Or the
specifically, one of the other co-defendants expressed, asked that the defendant Kitchens be made aware that he would be willing to whack somebody for him. And that's just what was found in the evidence that we've been going through so far. We continue to sift through the evidence. Statements like that cause us concern, for, you know, the real threat of witnesses feeling in some way influenced, pressured, intimidated. But even if it is not a request from Mr. Kitchens, hey, go out and do harm to this person on my behalf, when there are people who may feel like it would do him well to have things done to other people on his behalf, and they're gunning for, you know, favor in his eyes, those type of things cause us a real concern. So we would ask that the court, based on the fact that there has been no change in circumstance, deny the bond reconsideration motion.
okay.
Your Honor, we are once again getting this vague information, all by virtue of proffer.
Okay, but
And
a proffer is authorized
I understand.
under Title 17 at this point in time. It's a different standard than
I understand.
trial standard of beyond a reasonable doubt. And you all know, being seasoned advocates, that the state has to prove these assertions beyond a reasonable doubt at trial, as pursuant in the indictment.
Judge, I'm not questioning their authority to proceed by way of proffer. And in fact, that
Come to pass or come to fruition. That's no consultation or consolation for your client, Mr. Samuel and Mr. Sadow. And but you know, unfortunately, that's the best that the system can offer at this point in time, given the status of the case law and the like. The only thing I can potentially do is, like I said, I will try the case as expeditiously as possible. But at this point in time, I don't find any change in circumstances that would allow me to, or move me from changing my decision as to bond. And if anybody's in the gallery and you can't otherwise control yourself, or otherwise you want to make any appropriate comments, then you can leave at this point in time. No harm will come, or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
Oh, yo, it's Big Ant, the spokesman, man. We back. Another edition of Urban Politicians TV, UPTV. Make sure you stay on your pivot at all times, man. Had to come tap in real quick on Gunna. And as you can see right there, man, the judge was ready to throw his supporters in the courtroom in jail for having an outburst after he once again denied bond for Gunna. And that was the third bond denial right there. And I'm going to have links in the description from 11 Alive. They have now put in motion for a fourth request for a bond just 5 days later. And I'm going to read up the write-up in just a second, but this is how I go in court every single time. Look how vague they keeping it. I'm firm on my innocent until proven guilty stance. But in these courtrooms, niggas be really guilty and got to prove their innocence. Everybody been coming out saying, hey, look, Gunna doesn't have any criminal tactics or anything like this on his arrest or what he's affiliated with YSL, but they named him in one document as one of the top leaders, then they named somebody else in another document. And then as you heard right there, the prosecutor was saying, hey, yeah, he's not in the new indictment name, but that still doesn't change anything. They are using a text message and using statements made by other people and they evidence that they so-called claim that they have. And it's all about, can you convince the judge and convince other people that their character is bad enough and that, hey, their credibility as a person to be out in the free world on bond, they will not intimidate witnesses or they will be a threat to society. And in this case, they keep doing this with the judge. And as you saw him getting feisty, even with Gunna lawyer right there about the proffer and talking about, hey, when we go to trial, that stuff can be used. But right now in the bond hearing, this don't matter. And I'm going to keep it all the way 1,000. It sucks, but this is the way of the life. They innocent until proven guilty. But we've seen these type of things before. This is why I tell niggas, all this is a part of the streets, bro. When you jump in that water, you dive in that water, you might be up against things like this, bro. It don't matter if you done killed somebody, shot somebody or not sometimes. They will actually take you to court. And this is why niggas don't go to trial. Because trial is all about convincing the jury, hey, man, can this nigga have a possibility of doing this? This is a part of the game. I'm on the innocent until proven guilty. I feel Gunna and Duke should have a bond. We talked about Duke's situation on here. Watched it live where I was saying, oh, Duke finna get the bond. Duke finna get the bond. Because none of the drugs and guns was in his possessions, on like a little bit of weed. He completed his probation in the past. He doesn't have nothing like that on his record. And he completed everything else he went through. But because he's affiliated, they still did this. They still held him down and said, hey, I still believe that he has an influence and an impact. So it says this right here in the motion for the fourth bond that they trying to attempt for now on Gunna team. Gunna's attorney requests fourth bond hearing, claiming a Fulton County prosecutor misled a judge last week when she referenced a text message in which a co-defendant allegedly offered to whack someone for jailed rapper Gunna. The musician's attorneys are requesting a fourth bond hearing. In a motion filed Monday, attorney Steve Sato said prosecutors have continuously made claims that turned out to be false or misleading in their efforts to keep the star, whose real name is Sergio Kitchens, behind bars. Like I said, bro, the dude never even said, hey, Gunna gave me an order. They just said, hey, Gunna has influence on people to go out and do things for him. They saying the witnesses are crying. We ain't saw none of this. But they able to tell the judge that, and the judge gonna have the final say-so with how everything go at the end of the day. No matter if I like it, no matter if you like it, Gunna family like it in the courtroom, I'm firm on the innocent until proven guilty, man. But hey, we've seen these situations go down before. This is what you facing when you sign up in the streets, bro. This is how they do niggas for real. We watching rappers' cases in real time now. The game done got so wicked and it's out here bad now, bro. But I'm firm we'll keep y'all updated on everything. Innocent until proven guilty. We shall see. 1,000. Stay on your pivot for shit show.